I'd like to welcome viewers across the United States to this podcast on national security clearances, the process and the pitfalls that many people are victimized by in this process. I am Attorney Alan Edmonds, and I have been practicing security clearance, defense, and appeals for over 45 years. I am delighted that you're here today. This is a second episode on the adjudicative process, and we're picking up where we left off from episode number 1. We talked about the adjudicated guidelines, and there are 13 guidelines that we spoke about last time, and I highlighted the most popular guidelines that the federal government uses to remove your security clearance. We spoke about Guideline B, foreign influence, for people that have family or connections with a foreign country. That can be individuals that have relatives that were in the government of a foreign country, or they were in the military of a foreign country, or they own property in a foreign country, or they frequently visit that foreign country. Those are all issues you want to call us about to discuss. And as I've indicated before, and it's on the website and on this podcast introduction, the number is 800-481-2526. So foreign influence, as we discussed last time, is a huge area. And then Guideline D is sexual behavior. And of course, this is an area that encompasses all kinds of behavior that individuals can engage in. It includes adultery. It includes pornography. It includes criminal charges arising from domestic violence. It includes criminal charges that pertain to minors. And this is being alleged more and more, and is certainly a basis for a revocation of your clearance. The major guideline that we see often is Guideline E, personal conduct. And when we spoke last time, I discussed personal conduct as arising from the completion of a SF-86 or EQIP. And what happens here is that people fail to complete the EQIP accurately, and the government interprets that inaccuracy as a deliberate falsification. And of course, that goes to the issue of trustworthiness in the national security examination to see if you are eligible for a clearance. The Guideline E allegations go beyond just willful or intentional misrepresentation. They also pertain to false statements given on the EQIP, false statements given to an investigator, and they go to criminal charges. So you can be charged under Guideline E, personal conduct, even though you've been charged with Guideline J, which is criminal conduct. And as we discussed last time, and I received some phone calls about this, the government will charge multiplicious allegations to make sure that they are successful in revoking your clearance. I've alerted you earlier, and I'm going to repeat this admonition. This is not a friendly environment. The government is not here to ensure that you get a clearance. Rather, the government attorneys and the judges are very much alerted to misbehavior or misfeasance, and they're there to revoke your clearance. Now, a word about judges. They have taken an oath to adjudicate your case fairly and neutrally. But sometimes that happens, and sometimes, quite frankly, it doesn't. As you know, I've conducted over 3,500 trials in front of boards and administrative law judges in a variety of different agencies, including the DOD and the DOE. And you can get different results with the same fact pattern. Judges, by and large, are fair, and by and large, they do listen to the evidence. But like every other human endeavor, they have biases and prejudices that you and I are unaware of. And whether they impact the decision or not, we never know. So a word to the wise about you appearing in front of a judge by yourself. There's just too many variables, and there is so much riding on the security clearance hearing and the security clearance process that involves your job, your career, and of course, that impacts your family enormously. We talked about Guideline F, which was financial considerations, and I told you in our last meeting that was the number one basis and allegation used by the federal government to revoke your clearance. And this had to do with poor credit, inability to maintain payments on a loan, but it also dealt with taxes, tax filings, and tax payments. I've had clients that didn't file tax returns for 5 to 10 years. I've had clients that owed the federal government in back taxes tens of thousands of dollars. So there's all kinds of allegations that arise from this. There are people in the country that simply don't believe they should file taxes. And of course, the Department of Defense has a very strong position on that belief. So financial considerations is something that this law firm specializes in, and we take particular pride in presenting a very, very powerful case in court. But we also present a very powerful case in writing. And you should know that when you get a statement of reasons, you have an opportunity to win the case at that early stage and keep your security clearance in place. And it's a very difficult task, but our law firm has been very successful in that area. What happens is we send in a response that can be 25 to 35 pages in length, and it's reviewed, and the government says you have mitigated the concerns. And they send us an email saying we are withdrawing the statement of reasons, the SOR, which is the initial notice of revocation of your clearance. So the client is delighted. They received their clearance back, and they didn't have to go to a hearing, which is more expensive, very nerve-wracking, and very time-consuming. So we win at the very initial stages, and that's why we like to do written responses. As a point of strategy, some law firms say, don't do the written response, go right to a hearing. I disagree with that posture. I disagree with that strategy because it doesn't allow you an opportunity to have the case resolved at an early stage. And that's why this law firm, the Edmonds Law Firm, charges flat fees for each step of the way. You only pay for what you're using, and you're not paying inflated fees for a service that you may or may not use. So financial considerations is a huge guideline. We talked about that last time. And there are many, many variations of financial considerations, as well as personal conduct and foreign influence. I'm not going to address each and every one of them. Later on in this podcast series, we will take the individual guidelines and discuss them, and I will use some of my individual cases that receive favorable decisions, and we'll go in depth with each guideline so that you can see